Thanks very much for having me. It's a great pleasure. I was going to talk about, or I was going to hang my talk on this statement by Philip Alston that he made in 2005, which was that international human rights law and what were then the Millennium Development Goals are ships that pass in the night. In other words, that despite a sort of shared preoccupation with the necessary outcomes for improving people's lives that are shared by human rights law on the one hand and development projects on the other, they don't really talk to each other. And I think in a lot of ways that criticism, even though it's specific to the Millennium Development Goals, is still a valid starter point. And it's also kind of a paradoxical starting point, considering that in official rhetoric, at least on the human rights side, and I come from the human rights side, there is an assumption that development goals and international human rights are mutually reinforcing and fully complementary. So there is this assumption that even though there's two really diverse sets of discourses, the shared preoccupation somehow means that when there is overlap, that overlap is always positive, yeah? It's always a good thing, as opposed to there being any kinds of tensions or challenges in that. Whereas I think the practical reality often has been that in fact there is a tension. So what I wanted to talk about today was really the underlying reality that yes, human rights and development goals can be mutually reinforcing, but there is often also competition in terms of who gets to frame what we're talking about, and there's often tension in terms of trying to accommodate both in those projects that try to do both. Now, I should say that I obviously come to this from the point of view of international human rights law, so you can take it with a pinch of salt. In that, even though I agree that there are legitimate criticisms of the human rights approach, I think that's kind of my naturalized starting point. So I am looking at the development goals very much from the point of view of what, if anything, can human rights add to that discussion. Okay, now, just because we are a sort of diverse group, I thought I would say a couple of things about what human rights are, just by way of kind of easing everyone in. The lawyer part of the room can kind of close their ears and go, yeah, we know all this already. That's fine. So really when I talk about human rights, I mean the normative minimum standards that really arise originally from the Universal Declaration on Human Rights. Which is based on this idea of inherent dignity and value of every human person. So it's very much rooted in a post-World War II discourse of every person needs to be recognized as a person. Every person needs to be treated not as a means to an end, but an end in and of themselves. Yeah, and that's kind of the starting point of any human rights analysis of anything is to look at persons as the end rather than the means. Now, these universal entitlements have then been incorporated into legally binding treaties, and I've just listed two here, which are the most probably well-known ones and well ratified ones. So the International Covenant on Civil and Political Rights covers civil and political rights, as the name implies, and civil and political rights are in particular rights such as right to life, freedom from torture, ill treatment, right to liberty, freedom of expression, freedom of association, and so on. And these are very much rights that were especially initially conceived of as so-called negative rights. In other words, they were conceptualized as trying to ensure a sphere of freedom for individuals from state intervention. Now, the International Covenant on Economic, Social and Cultural Rights incorporates a very different original approach, which is the idea of making a person free to do something. Yeah, so it incorporates rights such as right to education, right to the highest attainable level of health, right to just and fair working conditions, etc., all of which really require state intervention. And of course, it's the set of economic, social and cultural rights which is more aligned with most of the development goals. Now, having said all that, I'm going to kind of summarize 70 years of legal development very, very briefly to kind of say that this division into negative and positive rights is kind of false in a lot of ways, because a lot of the civil and political rights actually require the state to do a fair bit to make them happen. Yes, so they're not purely freedoms from state intervention. So if you think about the right to a fair trial, or for instance, the right to a fair trial requires the state to put in place infrastructure to actually make sure that somebody can get a fair trial, and it requires infrastructure, it requires personnel, etc., etc. Similarly, a lot of the economic, social and cultural rights really aren't purely positive rights, in the sense that they do require the state to provide certain things, but they do also require the state sometimes to not do things. Yeah, so a good example of the right to education, for instance, is that it requires states not to prevent anyone from accessing education. So for instance, preventing girl children from going to school would be an interference with the negative side of the right to education. So there's a sort of long discourse that tries to bridge this gap, and one of the ways in which she's now talked about is through this discourse of all human rights being a coherent whole that is universal, indivisible, interdependent and interrelated. And really the idea there is that none of the human rights can be fully enjoyed without the others. Yeah? So you can't enjoy your right to education if you don't have the right to food. You can't politically participate unless you have freedom of association, and so on. So the idea very much with modern human rights discourse is that they're a whole that can't be that you can't distinguish, for instance, economic, social and cultural rights from civil and political rights and say, all right, well, here's what's relevant for us. In fact, they're all relevant in different ways, of course. So in the context of development, economic, social and cultural rights often take primacy, but the argument from human rights is that primacy cannot dictate kind of ignoring other rights that are relevant for that enterprise. Okay. That's just a very brief slide of all of the various rights in the UDHR. I assume, Becky, you're happy to share the slides if anyone wants them. I mean, that's just a visual representation in case you're already falling asleep. Okay, assuming that you're not. International human rights law is based on human rights as obligations, and in particular as legal obligations under international law. And the idea there is very much one of state responsibility. In other words, states have the right states have the responsibility to guarantee these rights in their domestic systems. So international obligations are adopted at the international level, and the states then have to ensure that they actually comply with them in their domestic systems. Now, you can separate different ways in which the state can comply with these obligations. So a typical way of dividing these obligations in conceptual terms is to ask whether the state is under a duty to respect a particular right, so not interfere, leave that person alone and ensure a sort of maximal sphere of liberty, whether it is under a duty to protect the right from violations from third parties. So for instance, in the context of labour rights, it is very often the role of the state to help protect employees against violations of labour rights by employers. Yeah? So that is an obligation then to have a system in place to ensure that labour rights are protected. And then there's a duty to fulfil, and this is probably the kind of broadest and possibly most nebulous one, which is to take positive actions towards reaching a particular goal. And of course, the duty to fulfil is particularly relevant for economic, social and cultural rights, where states are always required to take certain kinds of actions to encourage people to access education, food, shelter, etc., etc. Now, the nature of these international obligations does require the states to put in place domestic mechanisms to ensure that they are in compliance with the treaty obligations. Again, I'm going to skip like 500 pages of legal detail to basically say it also includes the right to a remedy. So it requires states domestically, in their domestic legal system, to also put in place mechanisms to ensure these rights. So to protect these rights, to respect these rights, and to fulfill these rights. And because these are legal obligations which states undertake to observe, and they take these obligations towards other states. So when states ratify human rights treaties, they make a promise to other states that they will comply with these obligations. There is there is a duty to then answer to the international community about how well states actually protect these rights. Now, this brings me to the international machinery for the monitoring and accountability of human rights, which again is a huge topic, but let me just say it exists. It is very big. It is largely at the international level under the auspices of the UN. There's lots of bodies, but the main separation is between so-called human rights treaty bodies on the one hand and the Human Rights Council, the UN Human Rights Council on the other. Now, for those of you who don't know, the treaty bodies are attached to each particular human rights treaty. So there is a treaty body for the International Covenant on Civil and Political Rights, there's a treaty body on the International Covenant on Economic, Social, Cultural Rights, and they're bodies of international experts, and they really have two jobs, one of which is to review states' reports on how they are performing in the area of that treaty, and secondly, to hear individual complaints from individuals who want to argue that their rights under that treaty have been violated by a state party. And those are the kind of two mechanisms under the treaty bodies. Now, the Human Rights Council is a very different beast because it is not a committee of independent experts, it is an intergovernmental body made up of states. And the main relevance for our purposes of that is that firstly it conducts a universal periodic review, which is exactly what it says on the tin. It's a universal periodic review of how states are performing that they give to other states. Yeah, so it is a more political, so the role of the treaty bodies is more legal, the Human Rights Council is more political. Yeah, so it involves the Commonwealth of Australia commenting on how New Zealand is doing on its human rights record. Now, the Human Rights Council also has special rapporteurs, many of whom work on thematic mandates that relate to a particular right and then report back to the Council. So you have special rapporteurs on a number of human rights issues like trafficking, like the right to education, freedom from poverty, etc., etc. And those really inform the normative work of the Council in terms of what is it that states are actually expected to do under those rights. Okay, now that was not a very brief explanation of human rights law, but it was as brief as I could make it. Okay, in terms of human rights and development, really there's been two discourses, and I'm going to do one really briefly and then focus on the other, because the first one, which is known as the human right to development, is a human right in and of itself. There is a collective, not an individual, there's a collective human right to development that was adopted in the Declaration on the Right to Development in the 1980s. And the general gist of this right to development is very tentative. It is not legally binding, it's in a declaration rather than a treaty, and it really became a kind of tool of political football, if you will, between developing states and developed states in the 70s and 80s in the context of resource distribution. Therefore, it's kind of gone nowhere as a freestanding right. And I'm going to kind of skip that for present purposes apart from that. Now, the other approach that I do want to talk about, is the approach of integrating human rights into sustainable development. And this is the kind of more productive avenue of encouraging debates among practitioners in development fields and in the human rights field to try and adopt a view of development and processes of development that are human rights friendly, for want of, as a sort of shorthand. And the idea there very much is that policies and institutions in the world, in the field of development, need to abide by the obligations of international human rights law, which at one level is a completely uncontroversial statement. Yes, they do, because states are bound by this, so any systems of development that they develop also need to be bound by this. How it works in practice is very, very, very different. And the focus there very much has been on accountability, participation, non-discrimination, which are kind of the central planks of the human rights approach. Now, I think I don't need to say a lot about the Millennium Development, the Sustainable Development Goals, because I presume everyone knows what they are. So there's 17 goals, 167 targets, like a very different set of goals than the Millennium Development Goals, which were short and simple, but also problematic because they were short and simple, and these are not short and simple, as I'm sure a lot of you know. Now, in terms of the human rights aspects of the Sustainable Development Goals, there was a much stronger involvement from the human rights community in the adoption or in the lead up to the adoption of the SDGs. And the High Commissioner for Human Rights, which is the UN hub for human rights activity, for one argued that the goals are strongly grounded in international human rights law. I think that is possibly overstating it somewhat, but it's certainly true that they are more grounded in human rights law than the previous goals were. And really the gist of the human rights approach to the SDGs is that is a sort of conviction that human rights are a precondition of sustainable development. And this is in some ways an obvious point and in some ways a controversial point. Yeah? So it's the idea that, for instance, economic growth and meeting a lot of the individual targets of reducing particular instances of poverty or maternal mortality, etc., they do not necessarily guarantee human rights, and they are not necessarily sustainable without an appreciation of international human rights as a whole. Yeah? So it's this idea that you need to take all of human rights seriously before any of these goals are actually sustainable. And the argument there is that human rights are kind of a guarantor of stability. Yeah? So insofar as it is, for instance, corruption, sort of elite mismanagement, or sort of forms of denial of participation that are hampering the application of the goals, the only way to address these is through a sort of comprehensive respect for human rights, in particular in terms of participation, non-discrimination, and so on. So that's kind of the idea, and it's not an uncontroversial idea. So some of you might have thoughts on that, but that's certainly the main driving force of the human rights approach to development. At the same time, the goals are very partial from a human rights point of view, so they only represent a sliver of what is kind of the broader human rights agenda. So there is a potential there for kind of distortions of the human rights agenda if it is taken to be fully complementary with the SDGs. So there's a kind of tension there, and then there's the tension, but also the kind of promise of the fact that human rights are binding, and this is in particular relevant in light of the reluctance of the states by and large to commit to the Sustainable Development Goals as binding legal goals. Yeah, so they're nice things to have, but are we obliged to abide by them? Not really. However, states are obliged to abide by international human rights law, so can we leverage that power of human rights law for the purposes of the Sustainable Development Goals is really the question there. Okay, now just briefly to mention two areas where that kind of leveraging is very much happening. These are SDG 5 and SDG 16. So SDG 5 is about gender equality, and 16 is about peaceful and inclusive societies with access to justice. And you can see from peaceful and inclusive societies and access to justice why human rights law is highly relevant, and law in general and legal institutions are highly relevant. But gender equality is a slightly more, I guess, interesting example, because a lot of the targets there come from an identification of particular human rights problems. So there is an identification of violence against women, reproductive rights, women's access to economic resources, all of which are discussed in great detail in the Convention on the Discrimination of All Forms of Discrimination Against Women, which is kind of the main human rights framework there. So these are the rights where the High Commissioner's Office work quite closely. These are the goals with which the High Commissioner's Office work quite closely in the development of the SDGs, precisely with the idea that we can leverage some of the synergies quite quickly, and they're the ones on which most has been done. Overall, though, and I'm painting with a hugely broad brush here. Overall, though, I think that it's fair to say that a lot of human rights lawyers consider the SDGs somewhat problematic. Either we ignore them because they kind of seem complicated, or they're problematic in a number of ways, despite the sort of dialogue between human rights lawyers and development experts in the drafting of the goals. And really the primary criticism, which was also the primary criticism of the Millennium Development Goals, was that these are a particularly bureaucratic exercise that isn't at all aspirational in terms of what should be achieved. In other words, they're technocratic, they're kind of pragmatic, they invite a very incremental approach rather than an ambitious approach. There's a plan to reduce basic inequalities, but it doesn't go very far. And the overall criticism, that if you want to summarize that criticism, it really is one of lack of moral ambition, if you will. Yeah. But of course, you know, I'll get to the end of the criticism of the human rights approach to this, so just keep that in mind. Now, the second criticism is that the goals are extremely selective. They ignore some human rights altogether. Overall, the approach to goals and targets isn't that interested in the structural causes of a lot of these problems in terms of access, in terms of maternal mortality, etc., in particular discrimination. So if you think of sort of maternal mortality, a lot of it has to do with discrimination against women and particular constraints that women operate under, and just saying, well, if we just, you know, provide more doctors, etc., it doesn't really deal with the questions of sort of marginalization, minorities who may be discriminated against in terms of intersectional discrimination, and so on. So there's an understanding that there's a sort of perception that the goals are really problematic because of what they include and what is excluded. Now the third criticism is the standard human rights criticism of any development approach, which is that they tend to be quantitative. They're focusing on the sort of greatest number of good things for the greatest number of people, whereas the human rights approach always starts with, because it starts with the individual person, always asks who are the weakest people and how can we lift, rather than go, you know, the rising tide lifts all boats, go, well, it really doesn't. And what do we do about those boats that are least likely to go up? What kind of special measures we can adopt to deal with those who are most marginalized, who are least likely to be able to benefit from the sort of generalized approach of just lifting aggregate standards. Yeah. And finally, there's the question of states having limited commitments. So in terms of what they're actually committing to, they're not binding goals, and the argument there is that human rights can kind of contribute to making that aspect at least better. So let me briefly kind of outline in very general terms the human rights contribution, or the alleged human rights contribution that may arise from international human rights law. So the central point really is the first one, that it is a people-centered approach to development. In other words, it's not development because of the indicators, because of the metrics that we have to meet, but it is because of the individuals who are the central subjects of concern there. And in relation to that comes the second point, which kind of is implicit in the criticism of sort of normal approaches, which is that human rights law in particular can help with this idea of no one being left behind in the goals. That you really need to ask the human rights questions of who are the most vulnerable and what do they need to be able to access clean water or sanitation or healthcare or whatever it may be. Human rights are also, because they are focused on participation and there is a right to participation, they're kind of represented as a way of ensuring meaningful participation. So a lot of development talk is about participation, but it doesn't really lead anywhere. Whereas the argument with the human rights approach is that it's the fact that human rights law guarantees the right to be heard in development programs that really ensures that participation is meaningful, and not just meaningful, but also locally entrenched. So this is the idea that it is only by engaging with human rights locally and asking what are the local problems in terms of access to a particular resource, for instance, that allows them then to use human rights language to agitate, yeah, for better access to services, for instance. Inclusion and non-discrimination is the reverse of the criticism. So the argument that human rights law is particularly alert to discrimination and exclusion of those who are most vulnerable, and it is by asking who is the most vulnerable that you can actually sort of make headway in development as well. Finally, there's the idea of human rights law's contribution by way of ensuring responsibility through the legal institutions, including the UPR, that ensures sort of accountability, transparency, and rule of law in development processes. And I just want to show you a quick slide. This is from the Danish Center of Human Rights, which is charting how many of the development goals are actually mentioned and discussed during the Universal Periodic Review. And as you can tell, there's so gender equality, and SDG 16, which is the institutions and access to justice, which are much talked about, but you can see quite a lot of discussion also of economic, social, and cultural rights. Yeah, so the standard economic and social rights in the Covenant on Economic, Social, and Cultural Rights are really kind of finding their way into assessing states' human rights records on economic, social, and cultural rights. Okay, finally, very, very briefly, what's the problem with human rights? Like, that all sounds fine and good, hopefully, or at least some of it makes sense. I really want to kind of draw attention to what the other side of the coin is, which is what is possibly problematic about trying to integrate human rights into development. Now, there's a number of these criticisms, but they kind of, broadly speaking, speak about human rights being inherently political, inherently overambitious or hugely aspirational, abstract, disjointed from local political realities, and fixated on law. And really the question of the political nature of human rights is well canvassed, and I'm happy to talk about any of these in more detail, but the argument is that human rights law is judgmental. It is judgmental, and it is, yeah, it is judgmental. It invites states to scrutinize and critique other states. Therefore, it invites a very confrontational approach to discussing these issues, which is not necessarily helpful for development. Yeah? The other criticism is that because human rights are pitched at a relatively high level of abstraction, it can be quite difficult to translate them into sort of the language of very gradual progress of development, and a sort of understanding among a lot of development economists, for instance, that political realities can often be a good reason for why no progress is made, whereas that kind of argument doesn't really fly with human rights at all, so they then become quite judgmental. And then there's what I find personally one of the most difficult criticisms, which is that human rights are, because they are about the law, they invite a particular approach, which is a legal approach, and in particular a legal approach that is focused on rights. And we know from critical legal theory that rights tend to be exercised by those who have the resources to exercise them. In other words, is human rights law, with its critique of how the most vulnerable are being left behind, in fact a way of leaving the most vulnerable behind, because those who are most vulnerable typically can't access legal strategies. So that's kind of a difficult one. Now Becky wants me to finish, so let me just mention no, she does. She's indicating to me that she wants me to shut up, which is fine. I will shut up. I just want to mention a couple of the development goals that are particularly close to my heart, or me. One is SDG 8 and the idea of decent work. And in particular, I want to mention the the really complex discussions that you can have in the sort of nexus of human rights and development about labor migration, which is often kind of assumed to be an unproblematic tool of development, regardless of the practical realities where labor migration is practically impossible for those who would most want to do it, and that is because of states' policies. And that really brings us back to the question of what are the rights of migrant workers and who are the most vulnerable of the migrant workers, and how can we actually make development work not just for the economies that benefit from the remittances, but for individual migrant workers. And the second point on that is this discussion of, in terms of decent work, the most indecent work, so slavery, servitude and forced labor, the discussion of what is globally states' responsibility for ensuring, for instance, that global chains of production are free from forced labor, which often take an incredibly individualistic approach where, well, as soon as you criminalize certain practices, you've done what you need to do, whereas in fact that is only kind of one way in which you can approach the dilemma of forced labor, which is incredibly prevalent and a sort of entrenched part of the global economy, really. So that, I'm interested in that, if anyone else is interested in that. Now, the other thing I'm interested in is particularly the SDG 3 on healthy lives, and in particular the gender aspect of SDG 3, where since the Millennium Goals, very little progress has been made in terms of looking at who's the most vulnerable. Yeah, it's still very much focused on sort of quantitative indicators, which are impossible to meet for a lot of states, precisely unless you kind of ask the relevant questions of why can certain groups not access certain rights. So I'm going to finish, but I just want to mention a really interesting study I read about SDG 3 a while ago, which basically said this idea of children's right to education, getting certain numbers of children into school, is really hampered by a lack of recognition of not just child labor, which a lot of children do, but in particular unpaid labor that children, and in particular girl children, do in the home. Yeah? So we've become better at kind of recognizing that children do a lot of work, and that impacts on their access to education. But we've been very bad at kind of asking, well, why, even though girl children and boy children do the same amount of paid labor, roughly, why is it that girl children still don't have time for education? And it's because they are expected to do large amounts of unpaid labor in the home. Yeah, they're expected to help with the household in a way that boys aren't. And until you kind of focus on those questions, it's useless to say more girls should be in education. Yeah, because you're just kind of preaching without actually engaging with where's the time going to come from. Yeah, who is then going to look after the household when that happens? Anyway, I've overrun, so I'm really sorry. Thank you very much for your time and your attention.